everyone. My name is Shazia Khan, and today's session is on contract law, and we are looking at unit learning outcome 4, which is to understand how a contract can be discharged. First, I just want to look at a summary of the last session, which was learning outcome 3, which was understanding the elements that may affect the validity of a contract. And we looked at things like misrepresentation. We looked at the different types of misrepresentation. We looked at fraudulent, negligent, innocent misrepresentation with reference to case law. We also looked at the doctrine of duress. We looked at cases such as the Caparo Industries case, with Flanagan case, Maskell, Barton case. Then we looked at also the different types of mistake, which were common, mutual, unilateral, and mistake by identity. And we used case law in regards to that. Finally, we looked at third-party interests, and we also looked at the remedies that were available at duress, such as rescission and affirmation, with reference to case law. Now we're going to move on to learning outcome 4, which is to understand how a contract can be discharged. So again, let's recollect. So what is a contract? Because it's important to identify what a contract is, and why it's so important in regards to looking at discharge of a contract. A contract is a legally binding promise. So this is either in writing or orally by one party to fulfill an obligation to another party in return for consideration. Consideration meaning monetary consideration. A valid contract is one that meets the basic elements of contract law. For example, you sign to buy a blue horse, and the horse is blue. You sign to buy a blue house, and the house is blue. Thus, the contract is valid. A voidable contract provides the option to rescind by either party. At the creation of the contract, it is valid, but it could be voided in the future. What are the essential elements of a contract? So 4 elements of a contract are legal requirements of the formation of a contract. So you've got offer, acceptance, agreement, and consideration. These are the 4 elements that must come about to identify that there is a contract in place. 4.1, you explain the different ways in which contract can come to an end. And we need to look at why contracts will come to an end, and that we'll be looking at when case law is brought in. So here we're looking at discharge of a contract, and this relates to circumstances in which the contract is brought to an end, where a contract is discharged. Each party is freed from the continuing obligations under a contract. A contract may be discharged by one of the following ways, which is on the slide. So by performance, by agreement, by breach, and by the law frustration. So by performance is that the contract runs its course, and the contract is performed. And then by agreement, this is where the parties agree to end the contract. By agreement with another party, with another contract. By breach of contract, the innocent party has a right to terminate for breach of contract when party does not deliver what was promised, and in repudiatory breach or another agreed standard of breach. And then by law of frustration, the underlying circumstances of contract change which material alter the performance requirements of the contract. So we're going to look at each one in a little bit more detail. So the first one, termination by performance. This is when both parties to a contract have performed all their obligations under a contract, including all express and implied terms, a contract comes to an end. Each of the parties have performed their obligations with perfect precision, exactly as it was specified in the contract. And if the contract is for a fixed term, say 2 years, if the contract has been performed within that 2 years as perfect precision, and then the contract would end at the 2 years. A few words about contract performance. Any deviation from contractual obligations will amount to a breach of contract. In Bolton and Mahadeva 1972, the contractor was required to install a central heating system. The heating system didn't work. The contractor couldn't claim payment. He didn't fulfill the primary obligation to heat the house. In contracts for services by a contractor, the obligation to perform may not be so strict. The obligation is usually not to achieve a specific result, but just to exercise reasonable care and skill when performing the contractual services. But it depends on the precise terms of the contract, what the contractor is promised to do. Circumstances of the contract may all allow payment for part performance of a contract on a quantum merit basis. A reasonable price is required to be paid for work performed at the request of the other party. This enables the performing party, the contractor or supplier, to get request of the other party to get paid fair and reasonable remuneration for their work. It also requires a contract where the obligations to perform are divisible, such as phases or milestones. Payment may be recovered for the obligations completed where the partial performance has been accepted by the other party, or the other party prevents complete performance by a party ready, willing, and able to perform, or a substantial part of the contract has been completed. An IT consultant to a contract tenders performance by attempting to perform their obligations under the contract. They are prevented from performing by the other party. Depending on the type of contract, the tendering party in this example is the IT consultant, may be considered to have discharged their obligations under the agreement and the contract terminates. If the consultant's tendered performance is refused by the other party, they may be sued for breach of contract. Further performance is not required, but the debt arising under the contract for products or services is not discharged. In debtor-creditor relationship, if a debtor tenders payment for the debt and the creditor refuses it, then they still need to pay. If the debt is paid after tendering performance, the money is usually paid into court as part of the defence of tender. Now, when we look at a contract which is discharged through performance, there's lots of cases that we need to look at in regards to that. The first one that is quite an important case is the case of which we're going to look at is the case of Cutter and Powell. I'll just give you a little bit about the Cutter and Powell case, 1795. The claimant's husband agreed by contract to act as a second mate on the ship, the Governor Parry, on a return voyage to Jamaica. The voyage was to take 8 weeks and he was to be paid on the completion. A term in the contract stated 10 days after the ship, Governor Parry, myself, master, arrives at Liverpool, I promise to pay Mr. T. Cutter from the sum of 30 guineas, provided he proceeds, continues, and does his duty as second mate in the said ship from hence to the port of Liverpool, Kingston, July 31st, 1793. 6 weeks into the voyage, the claimant's husband died. The claimant sought to claim a sum to represent the 6 weeks' work undertaken. It was held that the wife's actions failed. Payment was on the condition that he worked the ship to Liverpool. Since he did not fulfill his condition, the widow was entitled to nothing. The next one to look at is discharge, termination by agreement. is always open to parties to agree variations to their contractual arrangements. So this includes terminating it by an agreement. Both parties are able to consent to the termination of a contract. When they do, the mutual obligations to perform a contractual obligations comes to an end. Variations to terminate the contract. This termination may be by agreement, is actually a variation of the contract. As such, it must be supported by fresh consideration to be legally binding. So where parties have performance obligation, which is executory consideration, outstanding under a contract, an agreement to discharge one another from further performance will usually be a fresh consideration. That's enough to satisfy the requirement for consideration, making the termination by agreement legally binding. Legally binding variation for termination. For the agreement to be legally binding, there must be either fresh consideration from both parties, a deed releasing the other party from their obligations, so there's no requirement for consideration in a deed, a separate agreement supported by fresh consideration to amount to accord and satisfaction, or a promissory estoppel applies on the facts. Broadly speaking, an estoppel is made out when a promise is made to amend the contract by one party to the other. Secondly, that the promise intended to be binding and acted upon by the other party. And thirdly, that the other acts on promise and changes their position as a result. The contract doesn't need to say that the parties intend to change the agreement in the contract itself. Even where a variation clause says there's no variations or changes may be made to the contract, changes can be made to it by varying its terms. If there's contractual procedure in a variation clause to change it, that procedure should be followed. Conditions subsequent. Terms of contract can be built into contract to terminate it. These are known as conditions subsequent. A condition subsequent stipulates a state of affairs which causes existing contractual obligations to come to an end. The state of affairs, whether an event takes place or does not take place, does not have to be out of control of the parties. Termination for breach of contract. Termination for breach of contract requires repudiatory breach of contract. Here's the TLDR. Conduct is repudiated, deprives the innocent party of substantially the whole benefit intended to be received for performance of the obligations under the contract. This is known as the substantially the whole benefit test. Repudiated breach is often expressed as breach goes to the root of the contract. Is the breach serious enough? It needs to be a serious breach, not a breach of warranty. That is a breach of condition or breach of inanimate terms which deprives the innocent party of substantially the whole benefit of the contract are repudiated breaches of contract and therefore sufficiently serious to terminate a contract. A contract may set out different standards of breach such as material breach, fundamental breach, substantial breach, or serious breach. These alternative terms don't necessarily repudiate the breach. It depends on the proper interpretation of those words within the context of the contract. If the parties to a business contract agree to terminate by reference to those terms, are they able to do so? And just because there's no express right stated to permit a party to terminate in a contract, it doesn't necessarily mean that it can be terminated. Anticipatory breach. This is when one party expresses an intention to not perform their obligations under the contract, perform them in a way in which it is inconsistent with the original contractual terms. It is anticipatory breach. It entitles the other party to terminate. Conduct or behaviour amounting to anticipatory breach may be either explicit or implicit. Express words or writing ain't required. Anticipatory breach may be communicated by conduct, such as contractor behaving in a way that indicates that they won't perform when their strict legal obligations fall due for performance. When a defaulting party commits an anticipatory breach, the innocent party may wait and allow the party in breach to properly perform its contract obligations. If the party in breach does so, then the right to terminate is lost. They may sue for damages as soon as the anticipatory repudiation occurs and not wait for the date of performance. They may also have the option of affirming their contract by performing the obligations under it. In the case of White and Carter Limited and McGregor, the defendant tried to terminate the contract. The claimant refused to accept the termination and continued with performance under the contract, later suing the defendant for the full contract price. The claimants were successful in recovering the full contract price, and the option of accepting the repudiation or terminating the contract is not available where the innocent party requires the cooperation of the other party to perform the contract, or if they have no real interest in performance of the contract. Another case in regards to anticipatory breach is the case of Hoyster v. DiL-Unit 1853. In this case, the claimant agreed to be a courier for the defendant for 3 months, starting on the 1st of June 1852. On the 11th of May, the defendant wrote to the claimant stating he no longer wanted his services and refused to pay compensation. The claimant obtained a service contract elsewhere but was not to start until 4th of July. The claimant brought an action on the 22nd of May for breach of contract. The defendant argued that there was no breach of contract on 22nd of May, as the contract was not due to start until the 1st of June. It was held that where one party communicates their intention not to perform the contract, the need not wait until the breach has occurred before bringing their claim. They may sue immediately, or they can choose to continue with the contract and wait for the breach to occur. Okay, when there is repudiatory breach. When there's a breach of contract, it does not automatically discharge the contract. Once you have the right to terminate it, it must be exercised to terminate the contract. The exceptions to this rule are rare and limited. Until the right has been exercised, the contract continues in force. The right to terminate is exercised by telling the party in breach that the contract is terminated, and this helps to explain all the reasons why, to and when you do. When a contract is terminated, the performance obligations under the contract are discharged at the date of termination. However, performance of secondary obligations are not discharged and continue to enforce, such as maintaining the confidential information of the other party, or the obligation to pay damages for any losses caused by the innocent party. Wrongful termination. Attempting to terminate a contract in the absence of repudiatory breach is a repudiatory breach in its own right, even if you are mistaken and think that repudiatory breach has been committed. When that happens, it means that the other party to treat the contract as discharged and claim damages. This happens when an innocent party thinks they have a serious repudiatory breach and they don't. For example, in the case of Federal Commerce and Navigation against Molini Alpha, 1979, the owner of a ship wrongly believed it was entitled to repudiate the contract. It wasn't. The repudiation was wrongful, and therefore the other, now innocent for legal purposes, party could not treat the contract as discharge. That's because the owner was in repudiatory breach itself. Remedies for breach of contract. The primary remedy for breach of contract is damages. Injunctions may be available to restrain future breaches of contract, which assumes that the contract has not been terminated. Termination by frustration. Discharge by frustration occurs where it is impossible to perform the obligations under a contract due to a change in circumstances of performance of the contract after it has been signed. The change of circumstances must change the nature of the outstanding contractual obligations. And where a contract is found to be frustrated, each party is discharged from any future obligations under the contract, and neither party may sue for breach. And the allocation of any loss is decided by the Law Reform Frustrated Contracts Act 1943. So there's a case, the modern test for frustration is outlined in the case of the National Carriers and Penelope in 1981, where frustration occurs when there supervenes an event without default of either party and for which the contract makes no sufficient provision, which so significantly changes the nature, not merely the expense or onerousness of the outstanding contractual rights and or obligations from the parties could reasonably have contemplated at the time of its execution, that it would be unjust to hold them to literal sense of the stipulation in the new circumstances. I'm just going to put a video on for you in regards to termination of contract in regards to frustration. If you can see this video looks at the discharge by frustration in discharge of a contract. Sorry about this.
Contract law. Discharge by frustration. A contract may be discharged by frustration. A contract may be frustrated where there is a change in circumstances after the contract was made, which is not the fault of either of the parties, which renders the contract either impossible to perform or deprives the contract of its commercial purpose. Examples of frustrating events include the destruction of the subject matter. In Taylor v. Caldwell, the contract for the hire of a concert hall was frustrated when the hall burnt down. Personal incapacity through illness, disease or injury will generally render the contract frustrated. In Condor v. Barron Knights, the 16-year-old drummer for the Barron Knights was under contract to perform 7 nights a week for 5 years. He suffered a mental breakdown and was told by his doctor he shouldn't perform more than 4 nights per week. He told the band and they dismissed him. He brought an action claiming wrongful dismissal. His claim failed. The contract was frustrated due to his ill health. Where the contract becomes illegal to perform, it will frustrate the contract. In Fibrosa Spolka v Fairbairn, an order in council made it an offence to trade with enemy territories during World War II. This frustrated the contract between an English company manufacturing a machine for a Polish company. If a contract specifies that performance must be in a particular way, where a later occurrence means it cannot be performed in the specified manner, the contract may be frustrated. In Nicol and Knight v Ashton, the parties specified that the cargo would be carried by the ship, the Orlando. The Orlando was damaged and had to undergo repairs when the contract was due to be performed. The contract was frustrated as they had specified the particular ship. A contract may also be frustrated where it is deprived of its commercial purpose. In Krell v Henry, the defendant hired a flat on Pall Mall for the sole purpose of viewing King Edward VII's coronation procession. The price agreed was £75 for 2 days. Due to illness of the king, the coronation was cancelled. The contract was frustrated as cancellation of the procession deprived it of its commercial purpose. However, the contract must be deprived of the whole commercial purpose to amount to frustration. Herne Bay Steamboat v Hutton also involved King Edward VII's cancelled coronation. The defendant hired out the claimant's steamship. The purpose of the contract was to take paying passengers to view the Naval Review, which was part of the coronation celebrations. The defendants were also offering a day's cruise for the passengers. The Naval Review was cancelled. The contract was not frustrated. The contract had not been deprived of its sole commercial purpose as it was still possible to perform the day's cruise. A contract will not be frustrated where 1. It is more difficult or expensive to perform. 2. Impossibility of performance is the fault of either of the parties. 3. Where there is a force majeure clause. 4. Where the frustrating event could be foreseen. 1. A contract will not be frustrated merely because it becomes more difficult or expensive to perform. In Davis Contractors v Fareham, Davis Contractors agreed to build 78 houses for Fareham Council within 8 months for an agreed price of £85,000. Due to a shortage in skilled labour and material, the contract took 22 months to complete and was much more expensive than anticipated. The contract was not frustrated. It was still possible to perform the contract. The same principle was applied in Sakiroglu vs Nobly Thal when the Suez Canal was closed for shipping. It took 4 times as long and cost considerably more to carry the cargo via the Cape of Good Hope. The contract was not frustrated as it could still be transported by the contractually agreed date. 2. A contract will not be frustrated if the impossibility is the fault of either of the parties. This can be seen in Maritime National Fish v Ocean Trawlers. The claimant owned 5 fishing vessels, one of which was chartered to the defendants. The fishing vessels were all fitted with otter trawler nets which required a license. The claimant applied for 5 licenses, but was only granted 3 which he applied to his own boats. The contract was not frustrated since the claimant had chosen not to fulfill his contractual obligation. 3. Where there exists a force majeure clause, this will apply rather than the law of frustration. Jackson v. the Union Marine Insurance established that the clause must actually cover the event which occurred. 4. Frustration will also not exist where the frustrating event should have been foreseen. In Walton Harvey v. Walker and Humphreys, the contract for advertising on the roof of the hotel was not frustrated by the compulsory purchase order. They knew the local authority were looking to purchase it when they entered the contract. In Peter Cassidy Seed v. Osuastuckik Orpa, ants' eggs required an export license. After agreeing to the sale, the defendant was refused the license. The contract was not frustrated as he should have foreseen the possibility the license may be refused. Consequences of frustration. Where a contract is found to be frustrated, both parties are released from their obligations under the contract and neither party may sue for breach. The allocation of loss is decided by the Law Reform, Frustrated Contracts, Act 1943. Under Section 1, 2, All sums payable under the contract cease to be payable, and any money already paid may be recovered. Where expenses have been incurred, this may be deducted from the amounts payable or paid. This is at the discretion of the court and is subject to what is just and equitable in the circumstances of the case. There is no provision allowing expenses to be recovered which exceed the amounts paid or payable. Section 1(3) provides that where a valuable benefit has been conferred, this must be paid for. In summary, a contract may become frustrated where there is a change in circumstances, which renders the contract impossible to perform, or deprives it of its commercial purpose. A contract will not be frustrated if it is still possible to perform, nor if the event should have been foreseen. If there is a force majeure clause, or if the impossibility arose from the fault of either party. Where a contract is frustrated, the parties are released from their contractual obligations. Neither party may sue for breach. Any money paid up front may be recovered. Any money payable ceases to be payable. Expenses may be deducted from this. If a valuable benefit has been conferred, this must be paid for. This video is part of a series of videos on contract.
As we can see from that video, it identified what discharge of a contract is and what discharge by frustration is, and identified it with reference to case law where there was discharged of a contract that occurred. Cases, example of frustrating events such as important cases as Taylor and Caldwell, which we'll kind of go through a little bit later on, which is, I think, is in the next slide. They also looked at the Baron Knight's case in regards to frustration, fibrosis, Spolker, Nichols, Krell and Henry, and it looked at cases where there was no frustration as well, like the Davies contractors case. And also looked at the Tasakaku case, maritime and national fish case, but also looked at things like Jackson and the Union Marine case and the importance of this case. They also looked at in the video at the consequences of frustration and why it is so important to identify this when looking at the cases. So some cases did have frustration and some didn't. So examples of situations where frustration occurred, it was identified in the video, but we'll talk about it in more detail now. Frustration may occur in a number of situations. So the subject matter of the contract has been destroyed or is unavailable and was intended by both parties to be primary subject of the contract. In the case of Taylor and Caldwell, as mentioned in the video, 1863, a contract to hire music hall was frustrated when the hall was destroyed by fire. A party who is individual rather than a separate legal entity to the contract dies or is seriously incapacitated. The contract becomes illegal to perform due to the change in the law or, say, an outbreak of war. The commercial purpose of contract has failed, such as the failure of an event which the contract was based upon. Frustration will not apply to discharge a contract, and the case of, again, simply because of inconvenience has been caused or there has been an increase in the expense or loss of profit. And the case, again, which was mentioned in the video, was the Davis Contractors Limited and Farham UDC 1956, where it was agreed that council estate would be built at a fixed price. Due to the bad weather, strikes and shortages delays ensued. The estate was built at a loss. The contract had not been frustrated, it was just more expensive to perform. The contract contains an express provision such as force majeure case, dealing with eventualities which came to pass for case argued for frustration. That's because the parties contemplated the frustrating event claimed by including provision for it in the contract. Frustration is self-induced, and one of the parties which had a choice regarding performance or the event was reasonably foreseeable by either party as at the date of the agreement. Terms of contracts. There are a wide array of contract clauses that can appear in agreements to set up business-to-business contract cancellation rights. The ability to rely on cancellation rights lawfully depends on two elements. Firstly, the express terms of the specific contract itself, and secondly, the terms of the contract which would be implied by law. So even if a business to contract doesn't contain an express right to terminate, such as a termination or a break clause, implied rights may exist to bring about a contractual power of termination of the contract. It may be that the term of the contract contains an automatic renewal clause, and if a contracting party tries to terminate a contract and does have the right to do so, it is itself in repudiatory breach of a contract. COVID-19, coronavirus and termination. For example, it's widely accepted China is the workshop of the world. It is known for manufacturing goods of all standards. There's a real risk that the temporary closure of factories arising from COVID-19 coronavirus affects delivery on short supply chains and businesses that rely on just-in-time procurement. 4.2. Examine the difference between breach of conditions, warranties, and inanimate terms. We looked a little bit at this in Learning Outcome 3 as well. Contractual terms can either be conditions, warranties, or inanimate terms. Traditionally, contractual terms were classified as either conditions or warranties. The category of inanimate terms was created in the Hong Kong fire shipping case. It is important for parties to correctly identify which terms are to be conditions and which are to be warranties. Where there was a breach of contract, it is important to determine which type of term has been breached in order to establish the remedy available. Conditions. A condition is a major term of a contract which goes to the root of the contract. If condition is breached, the innocent party is entitled to repudiate, which means to end the contract and claim damages. And the case in regards to that was the famous case of Poussard and Spears, 1876, 1 QBD 410. Madame Poussard entered a contract to perform as an opera singer for 3 months. She became ill 5 days before the opening night and was not able to perform the first 4 nights. Spears then replaced her with another opera singer. It was held that Madame Poussard was in breach of condition and Spears were entitled to end the contract. She missed the opening night, which was the most important performance of all the critics, and publicity would be based on this night. Warranties. Warranties are minor terms of a contract which are not central to the existence of the contract. If a warranty is breached, the innocent party may claim damages but cannot end the contract. In the case of Bettini and Guy in 1876, QBD 183, Bettini agreed by contract to perform as an opera singer for a 3-month period. He became ill and missed 6 days of the rehearsals. The employer sacked him and replaced him with another opera singer. In this case, it was held that Bettini was in breach of warranty and therefore the employer was not entitled to end the contract. Missing the rehearsals did not go to the root of the contract. Inanimate terms. Inanimate term approach was established in the case of Hong Kong fire shipping, as mentioned earlier, where rather than classifying the terms themselves as conditions or warranties, the inanimate term approach looks to the effect of the breach and questions whether the innocent party to the breach was deprived of substantially the whole benefit of the contract. Only where the innocent party was substantially deprived of the whole benefit will they be able to treat the contract as at an end. This approach has been criticised for sacrificing certainty. Also, the innocent party may well be liable for wrongful repudiation if they treat the contract as at an end, where it is found that the breach did not deprive them of substantially the whole benefit of the contract. Even where the parties have themselves classified the term as condition, the courts can hold that if it was in fact only a minor term, and therefore breach of that term would not give rise to the right to repudiate the contract. Hong Kong Fire and Kawasaki Kisan Kasha Court of Appeal case. In this case, as mentioned in the video in Learning Outcome 3, a ship was chartered to the defendants for a 2-year period. The agreement included a term that the ship would be seaworthy throughout the period of hire. The problems developed with the engine of the ship, and the engine crew were incompetent. Consequently, the ship was out of service for a 5-week period and then a further 15-week period. The defendants treated this as breach of condition and ended the contract. The claimants brought an action for wrongful repudiation, arguing the term relating to the seaworthiness was not a condition of the contract. It was held that the defendants were liable for wrongful repudiation. The court introduced the inanimate term approach. Rather than seeking to classify the term itself as a condition or warranty, the court should look to the effect of the breach and ask if the breach has substantially deprived the innocent party of the whole benefit of the contract. Only where there's answered affirmatively is it a breach to be a breach of condition. 20 weeks out of the 2-year contract period did not substantially deprive the defendants of the whole benefit, and therefore they were not entitled to repudiate the contract. Cases, to compare the cases, the case of Schuler and Wickman Tools 1974. In this case, Schuler were manufacturers of certain tools and Wickman were a sales company granted the sole right to sell certain tools manufactured by Schuler. A term of the contract between the parties was described in the contract as being a condition and provide that Wickman would send a salesperson to each named company once a week to solicit sales. This imposed an obligation to make 1,400 visits in total. Wickman failed to make some of the visits and Schuler terminated the contract for breach of condition. It was held that despite the fact that the contract had expressly stated the term was a condition, the House of Lords held that it was only a warranty. Another important case is the case of Lombard North Central and Butterworth 1987. QB 527. In this, the defendant leased a computer from the claimant. The claimant was to pay £584 by 20 instalments every 3 months. A term of the lease agreement provided that the punctual payment was required, and breach of this term would entitle the lessor to terminate the agreement. The defendant got into arrears with the instalments, and the claimant took possession of the computer and sold it for £175. The claimant sued the defendant, claiming arrears and all full future amounts to £6,869 in total. It was held that the term related to prompt payment was a condition. The parties by their agreement had demonstrated that prompt payment was an essential term and the consequence of breach was clearly set out. Lord Justice Nicholas stated that even one late payment would entitle the lessor to terminate, irrespective of the effect of the breach. 4.3. Examine the doctrine of frustration. Overview of the doctrine. In English law, a contract may be discharged on the ground of frustration when something occurs after the formation of the contract which renders it physically or commercially impossible to fulfill the contract or transform the obligation to perform into a radically different obligation from that undertaken at the moment of the entry of the contract, as mentioned previously with reference to case law. Historically, the concept of frustration has been invoked to mitigate the onerous doctrine of absolute contracts, where performance of a contract is prevented by supervening events for which either party to the contract is responsible and loss allocation is required. The test for frustration. The juristic basis of the doctrine has evolved over a number of years. The English courts have over time rejected the notions of just solution, foundation of the contract, failure of the consideration, and implied term, and instead adopted the test of radical change in the obligation, which is currently regarded by leading commentators as the preferred approach to be used. That test was first formulated by the House of Lords in Davis Contractors Limited and Farnham UDC, as Lord Radcliffe put, Frustration occurs whenever the law recognises that without a default or either party, a contractual obligation has become incapable of being performed, because the circumstances in which performance is called for would render it a thing radically different from that which has been undertaken by the contract. Non-hec in Fodera Vini, it was not this that I promised to do, that special importance is necessarily attached to the occurrence of an unexpected event that, as it were, changes the face of things. But even so, it is not hardship or inconvenience or material loss itself which calls the principle of frustration into play. There must be as well such a change in the significance of the obligation that the thing undertaken would, if performed, be a different thing from the contract for that contracted for. Furthermore, it is not simply a question whether there has been a radical change in circumstances, but whether there has been a radical change in the obligation of actual effect of the promises of the party in light of the new circumstances. Vis-a-vis, the court will have to establish that the performance was fundamentally different in a commercial sense. The House of Lords has also accepted the view that the test for frustration is objective. For example, it is not subjective inquiry into the actual or presumed intentions of the parties, as was suggested by the rejected implied term test, because the discharge of a contract occurs automatically upon the occurring of the frustration event. However, the fact that the parties at the time of contracting actually foresaw the possibility of the event or new circumstances in question does not necessarily prevent the application of the doctrine of frustration. Key features of the doctrine of frustration. In J. Lauritsen A.S. against Wijimullah B.V. the superservant, 2 Lord Justice Bingham set out the following 5 propositions which he regarded as the essence of doctrine. Firstly, is frustration mitigates the rigour of common law's insistence on literal performance of an absolute promises. Secondly, the doctrine operates to kill the contract and discharge parties from further liability under it. Thirdly, frustration brings a contract to an end forthwith, without more and automatically. Fourthly, it should not be due to the act or election of the parties seeking to rely on it, so there must be some outside event or extraneous change in the situation. And fifthly, a frustrating event must take place without a party's fault. For example, it cannot be self-induced. Legal effects of frustration. The English common law view is that frustration operates not only automatically, for example, without the choice or election of either party, but also totally. What this means is that the obligations of both parties are wholly discharged insofar as performance of them had not fallen due to the contract was frustrated. Thus, a court does not have the power at common law to allow the contract to continue and to adjust its terms to the new circumstances. The reason why this approach has not found favour in English authorities is that it would lead to uncertainty in respect of agreed contract terms and create the undesirable situation of courts having to formulate contract terms for the parties. Finally, statements referring to a total discharge of contractual obligations are commonly qualified so as to make the point that frustration operates only as a ground of discharge of future obligations, for example, of those which have accrued after the date of discharge. The legal consequences of frustration relating to the recovery of payments made are broadly covered by the Law Reform Frustrated Contracts Act 1943. Practical illustrations of frustration. The expression frustration of a contract refers to the general doctrine of discharge by supervening events, irrespective of the type of event which brings about discharge. Over time, the English authorities have addressed a number of events that potentially give rise to frustration. The following is a non-exhaustive list of such events. Firstly, destruction or unavailability of subject matter. Secondly, death, illness or incapacity of a person in personal contracts. Thirdly, dissolution or supervening incapacity of corporation. Fourthly, frustration of purpose, cancellation of an expected event. Fifthly, supervening illegality or change in the law, either English or foreign law. Sixthly, an outbreak of war. 7, delay sufficiently long to frustrate the parties' commercial adventure, and 8, method of performance impossible or radically or fundamentally different. So this is a non-exhaustive list. There's more that could be added on to this. So we finished the lecture today on discharge of contracts, which is learning outcome 4, and the references that we used are in this reference list, which is review of convention on contracts for international sale of goods, Halilis termination contracts, and Lexology. So you need to refer to some of these resources when looking at the discharge of contract. Also, you need to go onto Moodle to get additional resources on discharge of contract and case law on discharge of contract. And the next session we'll be doing is learning outcome 5. Thank you for attending today's session, and we're finished now. Thank you.